All right, everybody. So I thought that I would pop on here, go over something here with you guys in the break. I thought that something that I think the defense is shooting for. I think this case is going to get resolved in one of two ways: either with a not guilty by insanity, which the jury would have the option to do if they find mental illness. But I also believe in Georgia they have a guilty by mental illness, and I think the defense is shooting for either of those two options. So I thought, you know what? A lot of questions I see in the chat about what that means. So I thought, you know what? Let me show you guys what that means in Georgia, what that looks like. So this is a uh, this is essentially what happens in Georgia. If a person is found guilty but mentally ill, they will receive the same criminal sentence as a person found guilty without the mental illness designation. But the court will also order that they be evaluated and treated for their mental health needs while incarcerated, which may include referral to temporary hospitalization at a facility operated by the Department of Behavioral Health and Developmental Disabilities, depending on the severity of their condition. So there it is right there, the severity of the condition, meaning what she's exhibiting at the time she goes in. Essentially, they will serve their prison sentence while receiving mental health treatment. So the key points to understand: they get the same sentence. The defendant would receive the same sentence as if they were found guilty without the mental health illness designation. So life without parole, life with parole. But while she's serving her sentence, she would get a mental health evaluation, and the Department of Corrections would evaluate her needs, and provide any necessary treatments. Meaning, in theory, she could serve her sentence entirely in a mental health institution. As it says here, possible hospitalization. Depending on the case, the court may order temporary hospitalization at a mental health facility for treatment. So she would get that treatment in, basically bouncing between the prison and the hospital. So once she was deemed fit for prison, they would send her back to prison. If she had problems that were so severe that she needed to go to the hospital, she would be able to go to the mental health facility, get treatment. But if she was sentenced to life without parole, she would never be free to ever walk around again. And all the benefits that I've talked about that I think would come out of something like this could be had. In other words, we could understand what was going on, and most importantly, no automatic release. A guilty but mentally ill verdict does not automatically result in a lighter sentence or early release from prison, and that's very, very, very important to understand. So now, contrast that with guilty, not guilty by reason of insanity. What that basically means is, if she goes to the hospital, gets cleared, she goes home. Now, it doesn't mean she's off of being evaluated or out of the realm of state control, because guilty by reason of insanity means that she will have to follow whatever the medical professional's plan is for her release. So if that includes that she's got to be checking back in with doctors, she's got to do X, Y, and Z, she will have to do that, because although she's found not guilty, the criminal responsibility aspect is relieved, meaning she's not getting a life sentence. She's not having to go to prison when she's able to go out and leave the mental health facility. She is able to go back into society with controls. So, as that was explained in the opening statement of the attorney. So I want everyone to understand, this lady is not going to be walking among anywhere, uh, regardless of what the verdict is here. She will not be free. She will be going away. The only thing at hand here is if she agrees and if she reaches the level of being able to function in society, and she's on her medicines and she's working her plan, should she be allowed to be free and at home and out among us, or should she have to go to the state prison until she has a flare up and then she's back in? The obvious concern is if it, I think it's twofold here. One, you send a mentally ill person into prison, I don't think she's going to really have a great outcome there. On the other hand, do we want her out and about in society to where she gets off her meds, or as this doctor said, she becomes medicine resistant, doesn't go on her meds, and then someone else gets hurt, someone else dies, someone else is hurt by her. So it's a tough one. But at the end of the day, in Georgia, Georgia makes this designation almost, I think, in the sense that they have to determine, did she have any sense of right or wrong at the moment this happened? So what we heard right now is simply that the defense is taking a two-pronged approach. What I believe they've just established is that she has mental health issues, that she's got mental problems, that definitely they played a part in the crime. That's the guilty by mental defect. Now, the next doctor we're going to see, of course, this doctor gets cross examined. The next doctor we're going to see is going to deal with, I believe, tying it into explaining how these things that she's been diagnosed with by this other doctor would have tied in at that moment of this crime. Now, there's a lot of things to point out here. The web searches, the leaving of the room, getting the knife, returning, closing the door, locking the door, afterwards asking about prison right away. Those are all things that are going to be allowed to be considered for purposes of the jury deciding, did she or did she not understand right from wrong? And those are all major factors. And if they do find that they think she knew right from wrong, the jury discussion doesn't end there. Now it's mental defect or not. Or do they believe she was just a cold hearted person who wasn't affected by mental defect? I believe the guilty by mental defect is where this jury goes, most likely. But I think the defense is shooting for the potential to say, hey, let's see if we can get the not guilty by reason of insanity if she was deluded enough at that moment and had a flare up. And obviously they're going to have a doctor that's going to come in and tie all this in and says, yeah, she might have been doing all these things because she's mentally ill, right? That's the mentally ill component. The question is, was there an awareness of any sort that what she was doing was wrong? And if they can say at that moment, she might have had awareness 20 minutes before and 20 minutes after, but at that moment, she was so caught up in her delusion. She was so caught up in believing that she had to do whatever it was she was going to do. She lost track of it. So, um, that's you know, that's what we have to look at. So Lisa McClendon says not guilty by insanity doesn't have a specific sentence. That's correct. She doesn't get a sentence at all. She goes. However, Lisa, here's the thing. There is an aspect to it that she will, when she gets deemed sane, okay, there will be a treatment plan she will have to follow that will be oversaw by the state. So she's never free of the state being in her life. At all. So Sela Knight says, at least a trial testimony from Jason showed the group drank urine as a withdrawal of Z. Women were of no intelligence. The government was out to get them. Held her phone, not allowed her to work. Well, yes, Sela Knight, all of that is absolutely aggravating to her mental illness, but that's not going to alleviate her criminal responsibility. This is an issue of criminal responsibility, and the way criminal responsibility is determined is, did she or didn't she understand at the moment that she did this, that what she was about to do was criminal? And that is going to be a very, very difficult thing for the jury to determine because, again, some of the factors that are allowed to be taken into account is the some of the things that have to be taken into account are the actions and behaviors right before, right after, and during. So I don't know if Z will get called, if the defense will call him or not. But in Georgia actually allows for lay people to give an opinion in insanity cases as to what they witnessed and observed. In other words, did they believe what they observed? Did they believe this individual was exhibiting the knowledge of that what they were doing was wrong? And if somebody says, hey, this is, I don't think she did. She was just out of it. She was in a state of mind that was out of it, and then suddenly came to, and then starts talking about this. Then it's confronted with blood, a bloody scene. The daughter stabbed. She's got stab wounds, which is all potential, right? That's all potentially is the way it could have happened. But the question is, did she right before? Now that's where we're going to have to rely on some of the medical professionals see what the cross-examination brings. Right now, this doctor has been brought in purely to demonstrate she was mentally defective. And mentally defective at the time. Not that she wasn't the criminal responsibility doctor. Like I said, there was going to be multiple parts to this. And then you take on into account that she freshly had a baby, and there's all sorts of things, and you even have completely healthy individuals who goes through the postpartum issues, and you have somebody with all the underlying issues she had. I assume we're going to hear some of that, with it. Melissa says, I'm disturbed that she searched how to harm others and how to leave, and she was trying to make a choice, in my opinion. This is so well. That the question though is, Melissa, is, obviously there's two sides to her, right? Is that the side that would go in it, and this doctor says, she's in and out of that delusional state. The question is, in that room at that moment, who was there? Was it her? And was it her, Chloe, or was it the deluded person who just took over and zoomed her out? And how present was she? Or did she give in and say, I know it's wrong, but I'm just giving in, and I can't? And that's where Georgia law is unique, in the sense that it actually says there's a designation where it's like she gave in. So if she chose to give in, they're going to hold her responsible. If she had no control of it at all, and it was something else takes over, and she was not present in her mind, which is the standard they got to prove, then she can be found not guilty by reason of insanity. And Georgia holds that insanity, that psychosis, could have been 30 seconds. But if in that 30 seconds she does this act and she doesn't know, in that 30-second period, she is completely devoid of any idea of right or wrong, she's found not guilty by reason of insanity. So it's going to be very difficult when they go back there. But the off-ramp for them, when it gets difficult in that room, is the guilty by mental defect, which I think many of the jurors in that room will be comfortable walking with, and that's why they're going to, that's what they're going to do. Lisa McClain says, people are conflating evidence that comes from the witness and what her lawyers claim, which is not evidence. Well, yes and no. I think that what they're doing is they're taking what the lawyers are saying, and they're trying to see the witnesses, because that's what you're supposed to do, is in opening statements. It's a guidepost on how to interpret these witnesses. Because at the end, that's what we have here. Is the attorneys guiding us to see what exactly are they trying to present. That's why a lot of times two things get missed, especially in a long trial, and jurors don't even remember specific testimony. Or in the case of the Ferris trial, you had the jurors saying they didn't even, like 80% of what that prosecution put forth, they didn't even rely on to get to their verdict, which is why it's very important you listen to the opening statements, but you listen to it as a guide. And then when you're listening to these witnesses, you try to figure out what is the purpose of this witness and what are they putting it on for. Brandy Little, yes, the state did rest their case, because the state really didn't, in the case in chief for the state, that was not the main event, because the defense took a lot of the case in chief out of play because they admitted the actus reus part of the case, which the actus reus is the actions of the defendant. So they don't have to prove that. Now they went through and they put up general medical information about cause of death, confirmed that she died. They went in and they put forth evidence that showed the state of mind of the defendant, witnesses that saw it, gave background. But Boost Spanier says, bless the doggos. Yes, indeed. Anybody that walks by my house is going to get told by my dog. So that's why it's such a short case. Lisa McClellan says, anything the lawyers say in the opening questioning is not evidence. If her lawyers say, isn't this true, and they say no, then it isn't true and not evidence. That's correct. The only thing that's evidence is the physical. There's pieces and exhibits that can be considered evidence, but witness testimony is the most important evidence in the case, and that is evidence. Anything the witness says, it is not the questions asked, it is the answers of the witness that are to be taken as evidence, which is what you should focus on. But listen, we're dealing with humans here. So the human mind will not always process things that way, and the human mind can be driven in a certain direction by the question asked and then receiving that answer. So that's why good attorneys know how to do that. But in this case, like I said, it's a sole focus. It's a very narrow focus on right and wrong, good and bad, and that's what we have to focus on here. Well, Pilola's mom, that's a very good point. But I believe the defense, I don't think the defense is contesting the Google searches. Um, but that's a good point, and maybe they will. Maybe in closing arguments they will. But I don't think the defense minds the Google searches to the degree of it demonstrates her mental illness before it doesn't. But of course, it's also damning evidence potentially that she was searching these things and aware of things. But I think the defense looks at them as like a two pronged approach. They're going to argue that that's signs of mental illness, so that's going to move her to worst case scenario guilty by mental defect, which is certainly where they want the jury to fall to if they don't go not guilty by reason of insanity. But but it makes their case easier to say, listen, she's definitely mentally defective. The question is, what was happening at that moment in that room? If Spillers was sending messages about wanting to take minors' virginity and threatening to kill people, oh, absolutely. I mean, that's what I'm saying. I mean, these guys were not good people. They're sick people, and I mean, if you go and watch it was a link dropped by Sam in my live yesterday. Absolutely, you can tell these guys are out there on another planet. If you look at Z's YouTube site, completely crazy. And again, if he comes in as a witness, we'll watch a little bit of it, but I'm not going to bring him into this unless he's publicly brought into the trial. Then we'll watch a little of his YouTube and contrast what we saw on the stand. In the meantime, we did drop that in there yesterday, so go back. I don't know if it's available or not, but you can catch it on YouTube. It's quite interesting. Um, but Selenite says the psychiatrist stated during his sessions she revealed Z took her phone. Um, right. I mean, like I said, that's something that they will be able to argue to the jury in terms of saying, but well, of course, Lisa McClendon, but the point of it is they're not stated for fact, but it does go to his credibility. It does go to his character when evaluating the witness's credibility. So it's something that is allowed to be taken into account. Of course, knowing that he's innocent until proven guilty, and none of those are proven allegations. Although what we do have, Lisa McClendon, is two guilty pleas, one of which he tried to say was an Alford plea, but the records did not say that. So we have two on record guilty pleas for assault showing the guy has a history of violence. That's not good either. So there were things that were already established as part of court that he pled guilty to. So there were two separate things. If you remember, that came out in the cross examination. Um, so that's what we have to look at there. Like I said, this is going to be a difficult case. This will not be an easy case for this jury. Doesn't matter whether it's misdemeanor or not, Lisa. It's still a crime of violence, and therefore that gets to go to the character of that man. And when you have someone who has any crimes of violence that are that he's been convicted of, and you think that he's around young children, he's around this woman, he's exhibiting and exalting the beliefs that he has. He says that women are below him, and he's the head of the household. It's clear to me that if he had a woman that decided to take him on or step above his perceived role of her, he's going to use violence, I think. And I mean, that's what clearly demonstrated to me. Now, if he's got a woman who's acting the way he wants her to act and staying at her level, he'd be fine with her. So, that's a concern. And especially when you have someone who's mentally ill like her, who's acting up and not being the person or not acting like the woman that he thinks she should be, imagine how he'd be treating her. But well, Lisa McClellan, the issue as the defense attorney pointed out, he said it was an Alford plea. which might be what he's telling everyone, but the court records did not reflect an Alford plea. It reflected a guilty plea. And it wasn't the lawyer just claiming. The lawyer's not allowed to put false information up that he doesn't have verification of. He had the criminal record right there. And when a lawyer speaks in court, it is to be assumed what they're speaking is true, as they could be disbarred or censured. And that is why when an attorney speaks, if it is proven that an attorney has lied to the court, or brought that to the court, or brought that before the court, or cross-examines a witness on it, they don't get to lie about what would be on that. But the bottom line is that that guy has verified convictions of violence. He's demonstrated that he is a kind of a little bit of an interesting thinker there, and I don't think he would hesitate to do what he needed to do to assert himself. As he said, his woman is going to do his stuff. Vegetarian, if he's a vegetarian, if he's a vegan, she's a vegan, or she can get out. Although I don't think for the women, based on what we saw on those messages in that article, uh, and those were, again, as you saw in that article, those are messages. Those messages again have not been proven in a court of law, to my knowledge, to have come. But if those are true, and it appears they came from him, highly disturbing individual who is a bit different than the way he portrayed himself. So that's what we have to do in there. All right, looks like we're back, guys. So I'll see you here on another break.